Expanded Operations and 2025 Volumetric Performance Fee Spending Proposal. I am Nilgün Atamtürk. I am the assigned administrative law judge in this proceeding. I'm joined by Commissioner Douglas, President Reynolds, Commissioner John Reynolds, and Commissioner Baker, and Commissioner Houck is joining remotely. A ruling issued on December 6, 2024 outlined the agenda and speaking order. Accordingly, we will begin with 10-minute opening statements, followed by 5-minute responses, and then I will invite questions from the commissioners. We will take one 5-minute stretch break after the opening statements. There are 9 parties today, including the applicant. When we call your name or your organization's name, please either step up to the podium or to the front desk to make your statement. We have circulated a document with speaking order. Please refer to that document and be prepared to come to the podium for opening statements. With that, PG&E, please proceed with your opening statement.
Thank you, Judge. Good afternoon. My name is Tyson Smith, and I'm here today on behalf of PG&E. We first want to thank the Commission for the opportunity to present this afternoon as we recognize the demands on your time at the end of the year and the inclement weather. We appreciate the heavy lifting of assigned Commissioner Douglas, Judge Atamtürk, and the Commission staff getting us to a decision by the end of the year. In most instances, the PD reflects a thoughtful and fair resolution supported by the record. We appreciate the hard work. We appreciate the recognition of the hard work by the Diablo team to achieve extended operations and prepare the application, and the acknowledgement of previously settled issues such as the reliability determination. However, there are 2 key issues where changes are needed. So today we want to touch on 1, the PD's failure to provide a tax gross up for the fixed fee, and 2, PG&E's plan for spending volumetric performance fees, or VPFs, which the PD denied. Both types of fees are substitute for return on rate base, and while they're subject to some restrictions, at the end of the day, the funds are unequivocally compensation and should be treated as such. But before getting into the specifics of the PD, I wanted to reflect for a moment on the progress that PG&E has made to extend Diablo Canyon operations at the state's behest and to highlight some of the customer benefits. Starting in September 22, so just 27 months ago, the state asked PG&E to extend Diablo Canyon under a unique new framework. PG&E has made tremendous progress since then, obtaining various regulatory approvals and outside funding to lower customer costs. Significantly, Unit 1 entered extended operations last month, so we're already in this brand new paradigm for Diablo operations envisioned under SB 846. And this is going to yield huge benefits for customers. Over the 5 years of extended operations, Diablo is forecasted to have a net financial benefit to customers of $3.5 billion. That's nearly $600 million in net benefits each year. So extending Diablo Canyon looks like a tremendous policy win for the state. A large greenhouse gas-free resource continues to provide clean, reliable baseload power while lowering customer costs. But there are aspects of the PD that counter the framework set out in SB 846 and that reduce or slow the benefits to customers, and those are what I wanted to touch on next. The first key topic relates to the fixed fees, the value of which is eroded by the PD by nearly a third, by failing to allow for a tax gross-up contrary to longstanding Commission precedent and practice. The fixed fee is PG&E's only shareholder return under the unique framework in SB 846. We don't earn a return on capital investment in Diablo Canyon, nothing. Just a single fee, which is expressly in lieu of rate-based return on investment. Despite this clear language, the PD treats the fee as akin to an expense and declines to provide a tax gross-up despite a long, uninterrupted Commission practice treating tax gross-up as a standard cost of service recovery item. We're talking consistent decisions back 50 years or more confirming that taxes are a cost of business which utilities are entitled to recover in rates and charges. Under the PD, PG&E's return, again, its only return, which is already limited under the statute, would effectively be reduced by more than $30 million per year. The Commission should revise the PD to provide a tax gross-up on the fixed fee. Second, the PD's denial of our proposed fee spending plan doesn't grapple with the extensive record. It's inconsistent with the intent of SB 846, and it delays benefits to customers that would have otherwise begun early next year. I'll start with the record. It contains extensive evidence that the planned uses fall within the statutory categories in SB 846, and it provides a basis for concluding that there's no shareholder payment and no double recovery. We proposed 8 programs for 2025, many of which satisfy more than one of the priority use categories. These uses include accelerated maintenance of hydro facilities to improve summer reliability, increased EV adoption, expanded building electrification programs, support for small business decarbonization, and funding for risk and resiliency programs. Just one example, the Batteries for Resilience program builds off an existing program to give batteries to an additional 500 residents served on circuits with known reliability issues. This program plainly satisfies Category F, increasing resilience by reducing outages. Yet the PD says nothing about how this program, or any of the other programs for that matter, could possibly fall outside of one of the categories of SB 846, or what additional information would be needed for us to show. We're flummoxed. Until SPD changes, customers are going to go another year with disruption for no apparent reason. Suffice to say, our view is that the testimony provides more than ample basis to approve the proposed work. And again, remember, this is also subject to an after-the-fact compliance review, so the Commission has ongoing oversight and an additional chance to weigh in on our proposed uses of these fees. The record also provides an ample basis to that point that there won't be double recovery. Several of the uses are entirely new programs, brand new programs that can't result in double recovery to date because they're new. The rest are accelerated work beyond GRC-approved amounts. We believe that the findings on this contradict the Commission's direction last December, which instructed us to focus on the planned uses in our first application, while the Commission still works out what's needed for that after-the-fact compliance showing in a phase 2 of another proceeding, which is still ongoing. So we did exactly as was directed, yet we're being dinged for doing so in the PD. Lastly, I touched on this a moment ago, the detailed showing that matches dollars spent to how it's not double recovered, that's only something that we can do after we've actually spent the money, when we're going to match the dollar for each category of accelerated work, show that there was no double recovery or shareholder payment as part of that after-the-fact compliance review. In the meantime, we believe the existing record is sufficient for the Commission to approve the planned uses in 2025, subject to the compliance review in 2026. Apart from what's in the record, though, the PD creates significant tax, accounting, and operational execution issues that are simply unaddressed in the PD. These must be resolved one way or another. On the tax front, because the $167 million in VPFs are not spent in 2025, we're going to have to pay taxes on those as income. And because we pay taxes on them, what's available to spend in 2026 would be reduced by nearly $50 million. Not approving the plan also creates a host of other tax issues around timing of deductions, operating loss carry forwards, and the need, as I mentioned, to collect for tax liability in subsequent VPF applications. The PD doesn't touch on any of this. In contrast, if the plan is approved and the funds are spent in the same year collected, there's an offsetting business deduction, no tax liability, we can spend the full $167 million next year, and the tax issue goes away. It's a similar issue on the accounting front. In effect, SB 846 says shareholders can't profit or receive payment from the VPFs. But because the PD prevents us from spending the fees in 2025, we don't have a corresponding liability to book to offset the revenue for those fees collected in 2025. So they're going to appear on our balance sheet as incremental income. This creates a bit of a catch-22 for us. On the one hand, we can't show profits or an earning increase to comply with SB 846, but accounting rules mandate that we treat it that way. As with the tax issues, approving the VPFs so that we spend in the year earned makes this accounting issue go away and eliminates this issue entirely. PD also causes operational execution issues to the detriment of customers. Work, as you can imagine, work doesn't just happen overnight. To efficiently spend the VPFs in 25 required us to build them into our plans for 2025, work plans and budget planning processes. But now that's in question. We're just a couple of weeks in the end of the year, and we don't have certainty about what we're going to be able to do, what funding is going to be available, and what work we might be able to do in 2025. I think most importantly from our perspective, failing to approve the spending plan means that we're going to have $167 million sitting in account unspent, despite clear customer needs and programs that are ready to execute in 2025. We believe this is the opposite of what was intended by SB 846, which focused on accelerating spending on customer priorities, not delaying them by a year or more. Again, the delay, the tax and accounting issues, all would be eliminated by approving the VPF plan for us to spend in 2025. Again, all subject to ongoing commission oversight in that later compliance review. At bottom, we think we're asking for two primary but straightforward changes to the PD to comport with SB 846. The Commission should revise the PD to apply a tax gross up to the fixed fee. That was the first issue I started with. And then second, should approve the VPF plan so that we can accelerate work to benefit customers. Thank you for your time and consideration.
Thank you, Your Honor. John Giesman on behalf of the Alliance for Nuclear Responsibility. I will focus on four key questions. Where are we now? How did we get here? What's wrong with the PD? And what should you do? So where are we? PG&E updated its cost forecast on October 11th, and the results are gut-wrenching. The revenue requirement for the first 14 months of extended operations jumped from $428 million to $761 million, an increase of 78%. The projected cost of the entire extended operations period is now $12.7 billion, as documented in A4NR's reply comments. That's higher than the $11.8 billion identified in the Cal Advocate's opening brief. What PG&E's updated forecast makes clear is that the cost of Diablo Canyon's extended operation between 2024 and 2030 will now exceed PG&E's projection of Cal ISO market prices by more than $5 billion. Measured by the size of expenditure on a single project, extending the operation of Diablo Canyon to 2030 has become the financial flagship of the Newsom administration's climate portfolio. PG&E's updated forecast translates to $147.74 a megawatt hour in costs for ratepayers and taxpayers, and $18 per megawatt hour less if you ignore the taxpayer subsidy. As you know, the Commission's Padilla report last May identified the average cost of renewable portfolio contracts signed in 2023 as $58 a megawatt hour. That's considerably less than half the cost of electricity from Diablo Canyon. In 2022, when SB 846 was being considered, the governor's cabinet secretary testified in both the Senate and the Assembly that the cost of extended operation was projected to be $75 a megawatt hour. Prior to PG&E's October 11th forecast update, A4NR's testimony had compared a lower range of Diablo Canyon cost projections between $96.53 and $114.53 a megawatt hour against the historical Cal ISO prices for the years 2021 through 2023. At costs between $96.53 and $114.53, the plant would have been cost effective only between 9 and 13% of the more than 26,000 hours during the 3-year period. So how did we get here? Two factors, really. First, a concern in 2022 that bringing new resources online was so beset by permitting delays and COVID-related supply chain problems that retiring the 2,280 megawatts at Diablo Canyon on schedule could jeopardize electric reliability. Second, after the governor's office persuaded the Joe Biden DOE to change its rules so that PG&E could become eligible, a belief that if the state general fund gave PG&E a $1.4 billion bridge loan, we could get a matching grant from DOE to quickly repay the general fund. The legislature was told, and I'm quoting, the $1.4 billion loan expenditure will be matched with $1.4 billion in federal revenue, which limits the requirement of any ratepayer or taxpayer money for that purpose, close quote. We now know that didn't happen. The same day Governor Newsom signed SB 846 into law, PG&E filed its grant application with DOE, but for only $1.1 billion, not $1.4 billion. The general fund's zero-interest, forgivable bridge loan to PG&E was $300 million underwater on day one. In the 2 years since SB 846 was enacted, the panic over potential electricity shortages has diminished. Last May, the joint agency assessment by this commission and the CEC found that 18,800 megawatts of net qualifying capacity of new resources will have come online by 2028, and more than 8,000 megawatts of that by the year-end 2023. The joint agency report concluded, quote, the proposed 2023 preferred system plan meets the reliability standard through 2035. The state remains reliable even under extreme scenarios, close quote. When Governor Newsom announced last April that the state had 10,379 megawatts of installed battery storage capacity, he was quoted in the national press as saying, quote, this is our biggest power source in California, significantly bigger than the last remaining nuclear plant in the state of California, close quote. The Cal ISO reported in mid-July that the battery storage capacity in its balancing area alone had grown to 11,200 megawatts by June of 2024. In late July, speaking to financial analysts on her quarterly earnings call, even PG&E's CEO, Patricia Poppe, climbed onto the bandwagon. And I'm quoting, on the reliability front, California has added over 9 gigawatts of capacity in just the last year, and it did the job. The state now has 10 gigawatts of battery storage that are providing significant benefits. This is more than double the battery capacity from this same time last year, close quote. The drafters of SB 846 anticipated both of these possibilities, that the cost of extended operations could soar beyond projections and that new supplies could negate the need for continued operation of Diablo Canyon. Accordingly, they built into the law a series of continuous, ongoing assessments by this commission, the CEC, and DWR. In the words of the Assembly floor analysis, these reviews were intended to be, quote, built-in off-ramps, close quote. Southern California Edison's letter of support for SB 846 pointed to the, quote, important guardrails for customer costs and off-ramps if the extension of Diablo becomes too expensive, close quote. Other supporters of SB 846 were equally sensitive, as IBW 1245's representative told both the Senate and Assembly, we stand ready to honor our commitment to have the plant closed when we know that the resources are available. So what's wrong with the PD? It abdicates the Commission's core responsibility under SB 846 and Section 451 to evaluate the cost effectiveness, reasonableness, and prudence of Diablo Canyon's extended operation. After the Commission concluded in D-23-12-036 that PG&E's deficient cost forecast had not provided an adequate foundation upon which to evaluate the cost effectiveness, prudence, or reasonableness of extended operations, the unexplained omission of any such evaluation in this PD is unconscionable. The PD also fails to uphold the ratepayer protections provided by Section 712.8, subsection C1C, regarding PG&E's costs of preparing for extended operation. These unlawful cost shifts aggregate to nearly $200 million. The PD also approves a PG&E forecast of substitute capacity costs for scheduled outages that is $165.3 million above the prices PG&E has acknowledged it could have paid for the same capacity. The PD also allows PG&E to charge customers in the Edison and San Diego service territories some $47.9 million for employee retention costs incurred before extended operations even commence. The PD mischaracterizes oversight of the DWR loan as, quote, a public review process, close quote, and ignores the conspicuously adverse provisions inserted sub rosa by PG&E and DOE into the final grant agreement despite such purported public review. In order to satisfy the requirements of Section 1757, your final decision will need to correct each of these shortcomings in the PD. When it's my turn again, I'll discuss PG&E's tax gross up and its VPF spending plan. Those are two things the PD gets right and PG&E gets very wrong. Until then, thanks again for this opportunity to address you.
Thank you, Your Honor. Good afternoon, Commissioners. My name is Nikhil Vijaykar, and I am counsel for the California Community Choice Association, or CalCCA. Thank you for the opportunity to address you this afternoon. And before I start, I should acknowledge Judge Adam Turk for a balanced and well-reasoned proposed decision. I'm going to focus on a single issue this afternoon, and that is conclusion of law 13 in the proposed decision. It's a narrow conclusion, but one that matters a whole lot to CalCCA because it is the tip of a mountain of ongoing issues across 4 different proceedings that currently have proposed decisions before this commission. I'm here to explain why the commission should not adopt conclusion of law 13. That conclusion says, if the commission adopts measures to mitigate excessive over or under collections in the ERA balancing account, PG&E should incorporate those measures into the Diablo Canyon non-bypassable charge via a Tier 1 advice letter and implement those changes in the next consolidated electric rate change filing with the commission. Now, you might be wondering, what do over or under collections in the ERA balancing account have to do with this proceeding, especially now that the ERA balancing account no longer includes the costs of Diablo Canyon? And the answer is nothing. The reason conclusion 13 is in the proposed decision at all has to do with an entirely separate case, PG&E's pending ERA forecast proceeding. In that case, PG&E has proposed measures that it claims would mitigate over or under collections in the ERA balancing account by capping the resource adequacy market price benchmark. That's the connection to this proceeding, the resource adequacy market price benchmark. As the PD correctly recognizes, the RA-MPB market price benchmark is the value of substitution capacity needed when Diablo Canyon goes on outage. But the PD gets it wrong, where it directs PG&E to import its RA-MPB cap into this proceeding. And a little background here should help explain why. The RA-MPB is an administratively determined proxy value for the value of the IOU's RA portfolios. It is not the level of payment that PG&E must make to any generator. We need a proxy value because we need to ensure that when PG&E uses the capacity attributes of its PCIA portfolio, for example, when it retains that capacity for bundled customer RA compliance, or uses that capacity as substitution capacity for Diablo Canyon, the right set of customers are paying for and getting credited for that capacity. In ERA cases, applying the MPB to value PG&E's RA portfolio ensures indifference between bundled and unbundled customers. Here, the RA-MPB plays a slightly different role. Applying the MPB ensures PG&E is appropriately crediting the PABA balancing account, which all PG&E customers pay, and appropriately charging the Diablo Canyon Extended Operations Balancing Account, which customers statewide pay, for the PCIA portfolio resources that it uses to meet Diablo's RA substitution capacity obligations. That's why the application of the RA-MPB is really about transfer value, making sure one group of customers fairly compensates the other group, not affordability. Affordability comes into play with regard to whether PG&E uses its own PCIA fleet or goes to the market for substitution capacity. That is an issue for the ERA compliance cases or for the Commission's review of DCPP Diablo-related costs. Now, let's return to conclusion 13 and the PD's reference to measures to mitigate excessive over or under collections in the error balancing account. That's the conclusion that's an error and must be deleted for a couple reasons. First, the PD in PG&E's ERA forecast case does not adopt a mitigation measure. And if that PD is adopted by this commission unchanged, then conclusion of Law 13 in this PD, in the Diablo case, is moot. Second, measures to prevent excessive over or under collections in the ERA balancing account have nothing to do with this case. Here, the commission must determine a reasonable forecast of the value of RA transferred from PABA to the Diablo Canyon Extended Operations Balancing Account. Third, changes to the RA-MPB calculation methodology and mitigation measures associated with the RA-MPB are simply not in scope in this proceeding. That's why the record includes virtually no discussion of this issue. And for that matter, MPB mitigation measures really aren't in scope in ERA proceedings either. That's because the market price benchmarks are not changed in rate proceedings. To the extent they require changes, the MPBs should be revisited in a rulemaking, and then any changes should be implemented in rate proceedings, like the ERA proceedings or the Diablo Canyon forecast proceedings. Finally, commissioners, even if the commission expects the benchmarks could change in 2025 following, for example, a rulemaking proceeding, conclusion of Law 13 should nevertheless be deleted. The retroactive application of a modified benchmark to rates that are already in place, because those rates would be in place, carries significant legal and policy implications, and none of those implications could or should be resolved via a Tier 1 advice letter. Commissioners, I'll close by observing that the RA market price benchmark has its tendrils in several different proceedings, including ERA and including this proceeding, but also including several others. So it is necessary to proceed with caution when modifying the application of that MPB. Each proceeding will offer its own set of factual and legal issues. Now, the Commission is well equipped to carefully consider those issues in each proceeding where the RA MPB arises and sort out those issues in a manner that the record of that proceeding supports. It should not, however, make changes to the RA MPB in one proceeding based on a faulty record. Thank you for your time. I'm available for questions later this afternoon.
Californians for Green Nuclear Power.
Good afternoon, Commissioners. I'm Dr. Marty Marinack from Californians for Green Nuclear Power. Since our founding in 2013, independent nonprofit Californians for Green Nuclear Power, CGNP, has advocated for extended operations of PG&E's Diablo Canyon Nuclear Power Plant. We are one of many groups advocating for the safe, abundant, reliable, cost-effective, and zero-emissions Diablo Canyon. Diablo typically generates the equivalent of 5 Hoover dams. CGNP strongly endorses the key ordering paragraph on page 84 of the proposed decision. This paragraph authorizes PG&E to recover a revenue requirement of $723 million covering the extended operations costs from September 1st, 2023 to December 31st, 2025. This is the net amount beyond the projected CalISO revenue for the period of November 3rd, 2024 to December 31st, 2025. CGNP's reply brief dated October 1st at page 4 shows that Diablo Canyon is expected to produce 42 terawatt hours during the record period. This yields an incremental cost of 1.7 cents per kilowatt hour. CGNP has previously noted the plant opponent's very high Diablo cost projections lack credibility. The California power grid was stressed frequently during the period from 2021 to 2023. CGNP previously noted that as SB 846 provisions regarding netting of the cost of Diablo Canyon's generation had applied then, California ratepayers would have received $1.3 billion in rebates. This rebate would have been noticeable on their power bills. The California power grid will be stressed in the future, and Diablo Canyon will provide benefits as long as SB 846 provisions still apply. Californians are getting a huge quantity of reliable, emission-free power from Diablo at a cost which is frequently below dispatchable fossil-fired generation. From a power engineering perspective, this is the valid comparison, instead of comparing Diablo Canyon to non-dispatchable wind and solar. CGNP also noted that Diablo Canyon's huge quantity of synchronous grid inertia, SGI, stabilizes the California power grid against generation and load step changes that could cause castigating blackouts. Each of the twin generators has about 1 million pounds of rotating turbines and generation components. This huge mass stabilizes the grid frequency at 60 hertz. CGNP showed that when California's other nuclear power plant, San Onofre, was shut down in 2012, instead of being repaired, its generation and large SGI contribution was largely replaced by out-of-state coal-fired generation. This was hidden behind a California-specific legal euphemism, unspecified power. Southern California Edison's power content labeling reported by California Energy Commission, CEC, shows that approximately 1/3 of the utility's default power offering since 2012 remains unspecified power. Earlier this year, CGNP raised data quality concerns with the CEC regarding this data. Perhaps this is the reason why most of the recent CEC labeling data is close to 2 years out of date. As further confirmation of CGNP's environmental concerns, we have shown that since November 2014, Warren Buffett's Pacific Corp has sold close to $1 billion of mostly coal-fired power at wholesale to mainly California entities. This daily spot market sales exploits a legal loophole. WEIM sales are not subject to the emissions performance standards established by 1386 of Parada. Thus, allegedly environmentally responsible California is outsourcing the toxic air and water pollution associated with this coal-fired generation. CGNP further hypothesizes that Warren Buffett's lavish direct CPUC lobbying, more than $2.5 million from 2019 to 2023, played a role in the commission shirking their environmental remit. Warren Buffett continues to lavishly spend on lobbying at the state and federal level to support this controversial plan for a Caliaso grid regionalization. This is despite steadfast opposition by the California legislature since 2016. The commission has already filed a letter of support at the so-called Pathways Initiative website, and CGNP continues to raise concerns, employing the recent precedent established in the 2016 U.S. Supreme Court decision, Hughes versus Talon Energy, and a pair of FERC decisions regarding Warren Buffett's likely successfully challenging of California 8P46 in federal court if Caliaso regionalization is enacted. Such a challenge could be an indirect means to close Diablo. In this cost proceeding, CGNP supports the commission's scope determination that allegation by plant opponents regarding Diablo safety are out of scope. CGNP requests the commission take official notice of this sentence in the NRC's December 5th, 2024 letter to the trio of organizations opposed to Diablo Canyon's extended operation. Quote, the PRB has considered the information in your new supplement and determined that there is no imminent safety concern that warrants the immediate shutdown of Diablo Canyon, end quote. Finally, CGNP agrees with PG&E on page 3 of their December 2024 handout to the commission. The framework should be fixed to align with legislation and benefit customers now. CGNP calls upon the commission to approve the proposed decision with PG&E's reasonable changes. All Californians are benefiting from Diablo's safe, abundant, reliable, cost-effective, and zero-emission power. Keep Diablo Canyon running.
Thank you. Next is Coalition of California Utility Employees. Off the record. Are you ready, Ms. Johnson?
Yes, thank you.
Back on the record.
Commissioners and Your Honor, good afternoon. My name is Darian Johnston, and I'm here on behalf of the Coalition of California Utility Employees. My comments today will focus solely on the volumetric performance fees, VPFs. CUE supports the rapid deployment of VPFs to accelerate or increase spending on SB 846 critical public purpose priorities. And we believe the PD loses sight of the applicable law and fails to make findings of fact specific to any of PG&E's spending proposals, yet at the same time denies PG&E's spending plan outright. The Commission must revise the PD to apply the applicable law to the facts in the record, which show that PG&E's spending plan should be approved. I want to start by clarifying the applicable law in this case. SB 846 reflects a political bargain struck between Governor Newsom, PG&E, and the legislature. PG&E would take on the risk of continuing to operate Diablo Canyon, allowing California to continue to have a major source of carbon-free power online. And in exchange, PG&E would earn compensation through the VPF. While this compensation should augment PG&E's revenue, it can't enrich shareholders. Instead, PG&E is required to spend VPFs to accelerate or increase spending on critical public purpose